minutes to see if anyone else is going to trickle in. Okay, well, with that, I think we'll get started. Thank you so much for joining me today. Um, really, today is meant to help educate and equip you with some information that hopefully you'll find valuable. So, of course, this is one of our KSW webinars. A little bit about me. All the information is on the website, but I'm a wills and estates lawyer at KSW. I work primarily out of our South Surrey office. However, I do travel around to our various locations across the Lower Mainland, or I should say the Greater Vancouver district. So I'm meeting clients everywhere. So wills and estates, what does that mean? Typically, it's a breakdown. So about half of my practice is helping people plan, right? Put their plans in place. So this is what we're going to spend most of the time talking about today. So wills, right, and all the ancillary documents. And then, of course, estate administration. So after someone passes away, there's things that we need to do. Oftentimes, we need to incorporate, right, or we require the assistance of a lawyer. So I'm helping a lot of executors or administrators with the administration of the estate. So that's a lot of what I spend my time doing. Like every lawyer, I'm going to, of course, be sharing information today. This is not legal advice. Information is meant to equip you so that when you do reach out to someone to assist you, you've got a little bit of information, you know what questions to ask, and hopefully I can just help start the conversation, right? And help you start thinking about some of the things that you need to be thinking about as you consider and take steps to put your own estate plan in place. Legal advice is tailored to the individual, right, based on the specific circumstances that they present. Okay, so I always start with an agenda. So here it is, introduction. We've done that. I like to always, before I kind of dive into any of the specifics, I like to share just some important concepts that are really foundational to estate planning. Then we'll talk about what the usual estate plan is. Um, Other things that may complement an estate plan beyond the quote unquote usual documents. And then I always like to spend a few minutes just talking about probate and what it means, what we actually do with it, and what happens after someone passes away. Sometimes there's a lot of focus on putting the plan in place, and we kind of miss that piece about actually advising or equipping, right, the people that we've appointed in our documents to actually carry out our intentions. And the more that we can do while we're alive, the less stressful it's going to be for those we leave behind. I always like to leave lots of time for questions. I'm also the type of presenter, if you want to interrupt me and pop something into the chat, feel more than confident doing so. If it makes sense, I will stop and address the questions right away. I don't want you to be sitting here thinking, my goodness, I have no idea what she's talking about, or that didn't make sense, and just kind of spinning. So pop it in the chat, let me know, and I will do my best to address the questions as they come up. But of course, also leaving time for questions at the end of the presentation. So again, going back to the concepts, right? So here, just to ground kind of what's happening when we talk about estate planning, I always like to categorize the conversation into three categories. So there's before death, death, and then after death. So before death, assuming we're capable, this is of course when we're putting our estate plan in place, right? We're making the arrangements, we're talking to individuals, and this is when our power of attorney and our health representation agreement, if we've put them in place while we're alive and capable, are in effect. Right? So this is what we're happening. This is some of the things that are happening. And of course, I'm oversimplifying here, but these are some of the things that are happening as before kind of, we lose capacity, or of course, before we pass away. So when someone dies, if they have a power of attorney and a health representation agreement, their authority immediately ends. I often get individuals that call and say, mom or dad just died, but don't worry, I'm the power of attorney. Doesn't matter. So as soon as that individual has passed away, those documents and the authority that they granted has ended. And immediately on death is when the will takes effect. So if the executor is not the attorney named under a power of attorney, right, then it's the executor who now has the authority. But I sometimes have clients as well who say, I'm just going to log into the bank account and do a few things, pay for the funeral as power of attorney. Unfortunately, right, that's not, that wouldn't be proper, because again, their authority has ended when that individual has passed away. And then, of course, death, right, is this important, obviously, a significant event, but it's after someone passes away that the estate, right, so all of their assets and liabilities is administered, right? So someone needs to do something in order to actually carry out the intentions, right, or what's been set out in the will. And depending on the nature of the assets, probate, which is a court process, which we'll talk about in a bit, may be required. So always as I'm speaking, I've tried to put in the corner of my slides, right, what kind of stage we're talking about. Again, I find that it helps kind of ground the conversation and keep people, right, kind of cognizant of what stage we're chatting about, right? Because once you've passed away, there's no opportunity to change your will, right? Or again, so these are kind of important pieces to keep in mind. The other important concept that I always start conversations with is just a brief conversation about how assets pass on death. Um, this is really, really critical and definitely has implications outside of the will. So the will is not the be all and end all. The will is one part of an estate plan, right, that we're wanting to make sure reflects your intentions, right, and is consistent with everything else that you've done. So assets, right, if they're held jointly, are going to pass to the surviving joint owner pursuant to the right of survivorship. So the classic example, right, would be a husband and wife who own a piece of property. Immediately on the passing of the first spouse, that asset is going to pass automatically to the surviving joint owner. What that means is that no part of the home is going to form part of the estate, right, or pass pursuant to the will of the deceased spouse. This same principle applies for things like bank accounts and also a safety deposit box. I've put a caution down there because it's not quite so simple. There is something called false jointures, and we'll touch on that briefly later. But all this to say, sometimes DIY planning is to, go into the bank and add a child onto the bank account, right, to make it a joint bank account. But that it's a little bit more complicated than that. We can't just start adding individuals to our assets so that they receive it on our death. What I'm talking about here is when it's a true joint asset. So both individuals have contributed, right? They truly operate and believe it to be both of theirs. Then the asset is going to pass automatically to the surviving joint owner. The other way that assets pass is by designation of beneficiary. So the classic examples of these types of assets would be an RRSP or a RIF, a LIF, a pension, depending on what your pension provides, a tax-free savings account, life insurance proceeds. These are assets that have a designated beneficiary. So what does that typically look like, right? If you bank at RBC and you've got a tax-free savings account, at some point, hopefully, someone has asked you who you would like to name as the beneficiary. That's a declaration that you make usually directly with the holder of that account, and it will set out who receives that asset on your death. Again, that asset then is going to pass automatically to that individual when you pass away and will not be distributed in accordance with your will. So, by way of example, if I have three children and I have named one of them as the designated beneficiary of my tax free savings account, but my will leaves everything equally amongst the three children, on my passing, right, the TFSA will go to the one child that I've named, and the everything else that passes pursuant to the will get divided a third, a third, a third. The result then is that the one child who received the TFSA will ultimately receive more of my assets than perhaps I intended. So, this is why we always take an inventory of assets and have discussions with clients as to, who has been named and so forth, because we want to ensure that all the pieces of your plan taken together reflect your ultimate objectives. We don't want things to be missed. And then once we know what's passing outside of the will, either by jointure or by designation of beneficiary, I, of course, have my will. So everything else is going to form part of my estate and be distributed in accordance with the terms of my will. Is there any questions so far? Okay, I will continue on. So, like I said, these are some of the components of a usual estate plan, right? Powers of attorney, health representation agreements, and wills are often what we're talking about as kind of the fundamental components of a usual or classic estate plan. There are more complicated documents that we can put in place or ancillary documents, but for today's presentation, I'm just going to be focusing briefly on the three of these. So, a power of attorney, I've kind of alluded to it at the beginning of the presentation, but what is it? A power of attorney is a document that I put in place while I'm alive and capable, whereby I'm appointing an individual to be my agent in the world to assist me with my financial and legal affairs, right? Like I said at the beginning, the authority of an attorney ends when the document is revoked, but of course, on my passing. Do you need it? I would say it's a resounding yes. If you've got someone in your world that you trust, right, you absolutely want to take steps to put a power of attorney in place, because this is going to ensure that there's someone in the world who's able to use your assets for your benefit should you become incapable of doing so yourself. If you fail to put a power of attorney in place during your lifetime and someone needs that authority, by way of example, you have a home, you've become incapable, you have dementia, let's say, you no longer have capacity to put a document in place. There's no one with the authority just because they're your child, your spouse, your friend. No one just has the authority to deal with your assets simply because it needs to be done. What an individual would need to do is step up to be what's called your committee, and that's an expensive and time-consuming court application that takes at minimum a number of months. That can be avoided with the power of attorney. I sometimes have clients that come in, and the reason for not doing it is simply because they don't have anyone in the world that they trust. In those instances, there's a lot of trust companies out in the world who will happily take this on for you. And of course, they're neutral, professional, can be a really good option for someone who just doesn't have that trusted friend or family member that they'd like to appoint. So not having someone doesn't necessarily have to be the reason why you don't do it. The next document that I want to touch on briefly is the health representation agreement. So the power of attorney handles our finances. The health representation agreement is appointing to someone to be our advocate in the healthcare decision-making context. Do you need it? Here I've put in probably. The reason for that is, unlike a power of attorney, If I don't have a health representation agreement in place, there's at least something in the legislation that gives an individual or kind of sets out who has the substitute. The term in the legislation is who will be my temporary substitute decision maker. So TSDM is the acronym that you might hear. The legislation at least sets out who that TSDM will be. There's a lot of reasons why we, despite, even if we like that, the people on that list. So just again, a brief overview. If you are married, it's your spouse. If you don't have a spouse, it's your adult children equally. If you don't have any of those, it's your parents. And if you don't have parents or they're not alive anymore, it's your siblings. And it kind of just goes down a tree. Um, so there's a lot of reasons to put a document in place, but one of the most obvious ones is, of course, if you don't like the people on that list, or let's say you have 3 children and they don't get along, um, or even, maybe you have a spouse or children, but you really want your best friend to be your advocate in a healthcare context, right? The reasons can be, vast. I've encountered many over my practice. Um, so, of course, the main reason, or one of the main reasons why an individual would be putting this document in place, is because they don't like who the TSDM is. There's even, but that being said, right, there's reasons for putting a document in place, such as, the opportunity to clearly record some of your wishes, right, to have the continuous representation as opposed to this temporary nature that kicks into effect for, I believe, under the legislation, it's a period of 30 days. So all that to say, there's a lot of reasons, but at least there's something, unlike with the power of attorney, where someone has the authority to speak and advocate on my behalf in the healthcare context. So sometimes people wonder, how do these two documents work together? Well, the classic example would be, I become incapable. I need to move into some sort of assisted care facility. So my power of attorney would be the individual who's paying for all of that out of my assets. And the representative would be the individual who's determining, right, well, what quality or what kind of care should I receive? How many extracurriculars should I be doing? And all those kinds of healthcare, personal, major, minor healthcare decisions that come up along the way. Okay, now to the main event. So we've talked about documents that are operating while we're alive, but of course the will is our document that's going to speak from the moment that we pass away. So what is a will? I always describe it to clients as a declaration of what you would like to have happen on your passing, right? So you're going to set out who's in charge and ultimately what they're supposed to do. It's really quite simple in a lot of ways. Do you need it? Of course, I'm biased, but absolutely, right? So we absolutely want to be putting wills in place while we're alive to clearly document, right, what we would like to have happen on our passing. Okay, so some of the things that a will involves, right? So when we're thinking about putting a will in place, right, some of the decisions that we need to make, right, include but aren't limited to, right, choosing an executor. So who's going to be the person that actually carries out the intentions that you've left, carries out the instructions left in your will? An executor, again, can be one person, it can be two people, it can be one person with a backup. Or again, if you don't have someone in your world that you trust, or perhaps you have kids, but they all live in the US, and so maybe they're not the best options, there are private trust companies that will happily, if you meet their asset requirements, will take on the role for you. So the appointment of an executor and the choice of an executor is really critical because this is the person who's going to be tasked with actually locating, safeguarding, and administering your will. So it's not something to be taken lightly. And in making that decision, you want to speak with the individual and ensure they're willing to take on the role. If we have minors or we're guardians of anybody, appointing a subsequent guardian in case we pass away is a really important decision. So definitely a good chunk of my clients are young families, either expecting their first child or having just had their first child. And one of the most important decisions that they're making, right, is who's going to be the guardian in case the, the parents or the current guardians are unable to do so. Another really important thing that goes into the will is whether any trusts are required. So, trusts are kind of an often misunderstood and somewhat complicated concept. A trust at law is a relationship between three people. It's a relationship between the settlor, or the person who created the trust, the individual who manages the trust, which is the trustee, and the beneficiaries of the trust. So we can create, and when I say trust, like that can be 1,000 different kinds of trusts. There's a whole bunch of different kinds. When we're talking about a trust and a will, we're talking about a testamentary trust, so a will, a trust that takes effect on our passing. And the classic examples, or where I see this come up most in my practice, would be if I have a beneficiary who's disabled or is receiving disability assistance, right? A person's with disability. I want to ensure that their inheritance is held in a properly drafted trust, because in doing so, I help them, right, not lose their disability benefits. So, an individual who's receiving assistance and receives an outright gift, right, will often be then in excess of the allowable limits and will be kicked off of their disability benefits. So, to prevent that, I can draft a fully discretionary, a lifetime discretionary trust, sometimes referred to as a Henson trust, into my will. And assuming that it's properly drafted with the help of a lawyer, that will ensure that that beneficiary, right, isn't isn't essentially disadvantaged, or isn't going to be, their benefits aren't going to be threatened at all. Other examples that a trust comes up are sometimes if I have a spouse, I might not want the spouse to receive all of the assets, but I'll want them to receive the benefit of it. So a trust that we put in the will is called a spousal trust. And probably the most common example that I draft is a trust for children. Right. So oftentimes, or grandchildren. So oftentimes parents or grandparents are in my office and saying, you know what, 19, right, which is the age of majority in BC, feels pretty young. I don't know if I would want, my child or my grandchild to have, full access to their inheritance at 19. So what we do then is we draft in a trust. Oftentimes that trust might vest or end when that recipient reaches the age of 25, 21, 30, but that's the decision of the client. And ultimately, then it's up for the executor trustee, right, the person managing those funds, to decide how and on what terms, right, the beneficiary should get access to the funds, right? So, paying for private school, sure. Assisting with university payments, sure. But, buying a brand new, I don't know, Mercedes or a fancy kind of car like that, they might say, no, maybe that's not the most prudent choice at this time. Right. So, and then parents are able to leave letters of wishes explaining how they would like those funds to be distributed and used until that vesting age. The other thing that we can do in our will is, of course, making charitable gifts. And just like during our lifetime, charitable giving through our will, right, has similar, if not even more flexible, tax benefits. So that can be a good opportunity, of course, to leave a legacy, but also to reduce a tax bill, right? And oftentimes we're dealing with, depending on the nature of the assets, a death can result in a large tax bill. Sometimes too, it's as simple as clients can't decide who the beneficiary should be. Perhaps you have children and it's easy, but for some of my clients with no biological children, it's not a simple decision. They can agonize over how their estate is to be distributed, and it can be a really challenging decision. So again, that's a decision that needs to be made. Some other things that get included in the will would be executor compensation. So again, as you're approaching your executor and asking them if they're willing to take on this role, one of the other things that you want to be asking is, are you expecting to be compensated? And if so, how much, or what would that look like? And a lawyer can help guide you through what the legislation says. And sometimes clients use that as a bit of a kind of a benchmark as to what's reasonable. Other decisions that I haven't listed in here, but which can be relevant to making a will would be simple things like, do you have pets and do you have special instructions for those pets? Would you like your funeral wishes to be included in your will? Would you like, do you have any items of significant value that should be included in your will, or even just sentimental value? Um, Pretty much anything to some extent can be included in your will. But that's the conversation with the lawyer and kind of understanding what your instructions are and ensuring that the will then reflects what you would like it to say and properly disposes of your assets. So, one of the things that we always have to be weary of in British Columbia is that we have something called the Wills and Estates Succession Act. And under that legislation, after I pass away, if my spouse or my children feel that feel that what's been left for them is not adequate and just, they can take steps to vary the terms of the will. What does this mean in practice? Well, let's say I pass away and I have 4 kids, but I've left it equally amongst 3 of them. The kid who was disinherited could start an application to vary the terms of my will. They would be applying to the court saying that 1/3 distribution isn't fair. It doesn't adequately provide for me. I think the will should be varied to provide X amount or this percentage to me. Um, it's very important to note that child in this context does not refer to a stepchild. It refers to and includes only a biological or adopted child. So, wills variation is really important for most will makers, but it's particularly relevant in a blended family context where we have parents, right, who have children from different relationships, so not the same biological parents. Because the fear is sometimes if husband leaves everything to his wife, which is often done not really thinking about it, or it might be done unknowingly because all of the assets are held jointly with that spouse, and that spouse has failed to realize that they have nothing to pass to their own children. If everything is left to the spouse, then on that spouse's subsequent death, right, if they leave everything to their biological children and disinherit or don't include their stepchild, that stepchild has no standing under the Wills, Estates, and Succession Act to bring bring an application to vary the terms of their step parent's will. And effectively, they have been disinherited from their parents' estate. So this is something that we're planning into often, and is something that we're always conscious of. It's always as well a reason for if we think that an individual might start a wills variation application after someone passes away, there are things or strategies that us planners can put in place to hopefully make that less probable. So that's called wills variation. In addition to will's variation, there's other factors that can complicate, or things again that we're planning into for our estate plan. I kind of mentioned it earlier, but some of these would be non-resident, right? So if I have children that are living outside of Canada, I might be taking certain steps to ensure that, from a tax perspective, they don't encounter more issues than they need to. Again, disabled beneficiaries, right? So ensuring that their money is drafted and dealt with properly. One of the things that can complicate an estate plan is just the nature of the assets. So, um, sometimes you have a business, but none of the arrangements have been properly documented, right? So it's just a verbal understanding that can cause issues later on. Again, I mean, the list can go on and on and on. Blended families is, of course, something that can add a layer of complexity to the estate planning, making sure both spouses are on the same page and confident in their plan. One of the things that too often concerns my clients is maybe, they're fearful or not really too keen on the spouses of their children, right? So, maybe they're concerned that their children are going to receive a large inheritance and then be divorced, and half of it's going to go to the ex. So things like that, I would say there's a number of not necessarily legal, but maybe personal circumstances that are influencing the decisions and what we're doing and what the documents say. Okay, so I alluded to this at the beginning, but I always like to spend just a brief moment talking about false jointures. So again, sometimes clients' response to, well, I want to, exclude a child, or I want to, avoid this, or I want to avoid probate, or I want everything to go to this one child. The answer is just to walk into the bank and put them on title to, all their bank accounts and those kinds of things. Unfortunately, that doesn't work unless it's done properly. So because of this concept of what I like to call false jointures. So if we have assets and we add someone on title who hasn't contributed at all to that asset, the law presumes, so again, the classic example would be a parent adding their child onto their bank account. The law presumes that that is, right, not a true jointure. Then, on the death of the true owner or the presumed to be true owner, the other owner needs to prove, right, that the intention was to create a jointure. In other words, they're not simply holding that asset in trust for the deceased person. Because if they're holding the asset in trust for the deceased person, then it forms part of the estate of that deceased person and is to be divided in accordance with their will. So, why you absolutely need legal advice is because lawyers can help document your intention at the time of transfer to ensure that your intentions are clear, they're on paper, and there's evidence to support what you're doing and why. This is the paperwork that the survivors are going to be relying on when people start asking questions. It's a lot more complicated than that, but I always like to just spend a few more minutes or just spend a few minutes talking about it because it's a question that comes up a lot and it's a lot more nuanced than just can I add someone onto title to you name the asset. So it's something that should be done. And going back to one of my initial slides, right, is it's part of your estate plan because it has an impact on your passing. And so we want to ensure that it is operating cohesively and consistently with everything else that you've done, and your plan's going to make sense when you pass. So the creation of false jointures, right, is part of your estate plan that your lawyer is going to be assisting you with, right, in the context of putting your entire plan in place. So just the reminder here, right, is obtain and then proceed with the assistance of your lawyer. Um, okay, so now we've talked about, what we're doing while we're alive, right? We're putting the will in place. In our last few minutes here, I just want to spend some time talking about, well, what actually happens when I pass away? So I've done a will, I have an executor, it has a distribution, but what's actually going to happen? So, the first thing that usually an executor does when someone's passed away is determine whether or not they require probate. So, probate is a court application whereby the executor is submitting the original will to court so that the court can issue a grant of probate. A grant of probate is what allows the executor to actually go to financial institutions and the land titles office and deal with the asset. Without the grant, right, the banks and the land titles office will not transfer property to the executor. The grant effectively operates like legal comfort, giving financial institutions and the Land Titles Office, right, confidence that when they transfer the asset to the executor, right, the executor has gone through the checks and balances, right, they've gone through the proper process. Everyone who needed to know about the application has been notified of it. And so when they transfer the asset to the executor, they're not liable if that executor, goes kind of rogue, right? Goes does something they're not supposed to do. Or it turns out there was actually a later will and that executor wasn't truly the executor, right? Um, so a grant of probate is effectively legal comfort, and depending on the nature of the asset, it might be required. So assets that require probate to be administered would be real property, bank accounts. It can include cars of significant value. Those would be the assets that most often require probate. There's certain assets, like say if you only passed away owning artwork, that don't require probate. Um, but I would say most people in British Columbia, if you own any kind of bank account, even if it's not of significant value, and a house, probate will be required on your passing. So how long does it take, right? So an executor needs to get probate. How long is it going to take? Well, it depends on a number of things, right? So it depends on how organized your executor is, how soon they can start the process. But then once the process is started with the help of a lawyer, there are some waiting periods. So we do a little bit of work and then we have to wait per the legislation. And then once we're actually ready to submit the application, right, we submit it to the court. Every courthouse has a probate registry and we submit it and then we wait. So they're actually reviewed by real live people that work at the courthouse. And the waiting period can vary anywhere from, 4 weeks to 4 months, depending on how busy they are and what probate registry we apply in. So it takes some time. How much does it cost? Well, of course, you have your legal fees, but why people often cringe when you say probate is that what happens is you submit your application to probate, and then when the court has reviewed it and conditionally approved it, they will request payment of probate fees. They will not release the grant until the probate fees have been paid. Probate fees are payable on the value of the assets that pass pursuant to the will. So probate fees right now are currently calculated at 1.4%. So one of the application documents for a probate has a list of all of the deceased assets. So let's again just imagine it's a a piece of real property and then a series of bank accounts, right? We would tally up the total and then probate fees would be payable on that balance. So it can add up depending on what the nature of the assets are. And again, probate fee avoidance. So if you're someone who, depending on the nature of your assets, or you just really don't want to pay probate fees, probate fee avoidance or probate fee minimization is one of the things that estate planners are doing often for their clients. So we're looking at ways to minimize probate fees um, to ultimately save the client, well, not necessarily the client actually, but their beneficiaries money. So there are strategies that we can put in place depending on the nature of the assets, right, and the age of the individuals to avoid, if not entirely, partially probate. And again, only for the purposes of avoiding that 1.4%. So once probate is actually received, what happens? So once the probate is received, then the assets can be transferred to the executor, and then the executor has the authority to go about and do what they need to do. So again, this could be things like closing down the bank account, selling the real estate, selling the cars, all of those things. One of the things that an executor is going to be doing simultaneously is filing taxes, right? Working with an accountant to ensure that all the taxes are paid and up to date. And then just again, a super quick note, but what they're going to be doing is they're going to be showing the beneficiaries, right, what you've done or what they've done since the individual passed. So they have to account to the beneficiaries of the will. And then once they've accounted, everyone signed off, they will ultimately distribute the estate. Now, there's way more steps to it than this, but I always like to kind of ground the conversation in just a little bit of information as to, what's actually going to be happening when someone passes away. And this kind of all circles back to the wills and estates planning, because oftentimes clients have questions about, well, I want, both my kids to be executors because I want them both to be in control or know what's going on, right? But if we understand how probate and how the executor is to operate right after we pass away, right, we can take some comfort in the fact that an executor ultimately, right, needs to account to the beneficiaries. So they are accountable to the beneficiaries, and they do have to show them what they've done and how the assets of the estate have been administered. So it's not that an executor just to kind of gets to go totally right out there and do whatever they want to do, never tell anyone, and just cut a check at the end of the day. That's not the process. So there are checks and balances to ensure that the beneficiaries, right, have been kept informed, kept in the loop, and are aware of what's going on. Um, these are just some of the steps, right, that are taken after someone passes away. Okay, that's all that I wanted to cover today. I'll leave it just for a few moments if anyone wants to ask a question or pop some questions in the chat. I'll give it a couple minutes, and if there are none, we'll sign off. But I'll give you some moments to type or to pop on, whatever works best. Okay, so there's a question that says, the executor on my will has passed away. Do I need to do a new will? Um, the first question I would have would be, is there an alternate named in the document? And assuming there's not, or all of the executors have passed away, we would probably want to name a new will or have a new will, because then you could control who the executor would be. However, I do always mention to individuals that if I have a valid will but no executor who's alive and capable, the will is not invalid. So, what essentially happens is someone steps up after the individual has passed to be the administrator to administer the will. So, if I die with no will in British Columbia, then I have no executor, and the person who's appointed as part of the probate application to be kind of in charge of my estate is called the administrator. The only issue with that is that there is a lag between date of death and that actual appointment. And what that means is there's no one with the authority to deal with my estate in that period of time. Um, so we typically, sorry, just a follow-up comment that the alternate is even older than the will maker, but still alive. So like I say, this is one of the reasons why we probably do want to update, just to ensure that one, I get to choose who the executor would be, and two, to ensure that there actually is someone with the authority to deal with my estate or speak on behalf of my estate until the grant of probate is received. If we rely on the appointment of an administrator, we're hoping that someone steps up, that there's no dispute as to who that person should be, as in there's consensus amongst the beneficiaries. And we're also just appreciating that there's a lag, right? So there's no one with the ability to deal with the estate's assets until then the administrator has been appointed, which can, it creates headache, and possibly, just frustrations and unnecessary hurdles. Who do you contact to update your will? That would be me. Anything else as we wrap up? Um, if any questions have come up or as you're thinking about the presentation moving forward or in the coming days, you're more than welcome to email me any follow-up questions that you have or pick up the phone and ask away. We do my best to share any information that I can. But like I say, if it's kind of the analysis or kind of specific recommendations on your will or your circumstances, that would be legal advice. Well, thank you so much, everyone, for joining today. I really hope that it was valuable, and if nothing else, that it's given you cause to open up your documents, remind yourself what it says, and to consider whether any updates are required. One of the things that I see often is that people just they do wills and to be honest they just forget what they say, so sometimes they think that it says something, but then when they actually look at what they've done, it could be something totally different, or maybe they never made that update that they thought they did. So we just always want to be double checking, reading, reviewing our documents to ensure that they still reflect our intentions, and then if it's required, make any updates. Well, thank you so much. Have a wonderful afternoon. And perhaps I will hear from you in the future. Bye for now.